Good afternoon. The 14B District Court is now in session. My name is MIWashington, and I'm the judge that will be presiding over this session. The phone number that ends in 5925, could you please tell us your first and last name?
Tika Gregory.
Thank you. We're going to put you back in the waiting room. You're not on our first case. We'll call you back in when you're ready, when we're ready for you.
Thank you.
Samsung, I guess. Right, exactly. There's two Samsungs?
Yeah, there's no.
Good afternoon, sir. With the Samsung, could you please tell us your first and last name?
Is that me? Is that me?
Yes, sir.
I'm sorry, Ricky Bernard Eddins, Eddins.
Thank you, Mr. Addings. We're going to relabel you on the screen so we know who you are and place you back into the waiting room. You're not the person we're looking for just yet. We'll call you back in when your case is ready.
Okay, I was trying to change it, but I don't know.
We fixed it.
But okay, thank you. That's for the E though. All right, CKEY.
We'll see you when it's your turn, sir.
Hello,
Good afternoon, ma'am. Could you please tell us your first and last name?
Nevaeh Hall.
Thank you, Ms. Hall. You are not who we're looking for either, so we're going to put you back into the breakout room, in the waiting room until your case is ready to be called, okay?
Oh, thank you.
You're welcome. I don't see anybody else. All right, the court will call the matter of Credit Acceptance Corporation versus James Thompson, case number 23C 3314.
Good afternoon, Your Honor. Michael Beach, BEACH, P45459 for the plaintiff.
Good afternoon. Mr. Beach, we have, as you could tell, been trying to figure out whether or not Mr. James Thompson is present. There is no one else in the waiting room that is not labeled who would be Mr. James Thompson. There, she's on that big case. All right. So, having said that, sir, have you had any contact with Mr. James Thompson?
No, Your Honor. After the pre-trial, we sent him out some discovery materials on 12/21. Those were never responded to, and he's never called us up for an extension or to anything to discuss the matter.
All right. What is your request today, sir?
Your Honor, we're seeking the entry of a default, and we'd be willing to submit a default judgment under the 7-day rule if that's okay with the court.
Yes, I will enter a default in this matter for the defendant having failed to appear. And if you could submit that documentation on the 7-day rule, I would appreciate it.
Okay. Thank you, Your Honor. We will do so.
Thank you. Have a good day.
Thank you. You also.
Next one. Okay. All right. Oh, who's on? No.
No. Okay, there I am.
The court will call the matter of Reliable Auto Finance versus Nevaeh Hall, case number 14C 4427.
Yes.
Good afternoon, Your Honor.
Good afternoon, Mr. Chisholm. Please, first of all, are you able to fix your screen? You're just black.
Judge, I'm on a brand new device. I literally was issued this thing right after lunch today. I was screwing around trying to figure out what's missing. There's a setting or something. I don't know why, and I'm not able to to figure that out. But anyway, for the record, Your Honor, it's Jeremy Chisholm, P74670. I am the attorney of record for the plaintiff.
Thank you. Do you have a cover over it, perchance?
No, no,
Okay.
there's not. In fact, this computer doesn't even have a cover on it.
Oh, okay. Thank you.
I
Miss-
look, that was the first thought I had when I looked at it. It's got a wide open lens. I'm not.
Ms. Hall, if you could state your name, please.
Nivea Hall.
Thank you. We're here today on your objections, Ms. Nivea Hall. You indicate that the writ was not properly, it's an objection to the garnishment and notice of hearing. Your writ, your notice indicates that the writ was not properly issued or is otherwise invalid because voluntarily gave the car back and due to health issues. I'm not sure how that, there are certain criteria that you have to meet in order to not have a garnishment issued. There's already been a judgment that was issued in this case. So, ma'am, with respect to voluntarily giving the car back, that does not dispose of the fact that you have a judgment that has already been entered in this case. So, if you could please argue whatever it is you're arguing with respect to the garnishment, and then they will get a chance to respond.
Okay. My thing is with this amount is that I voluntarily gave the car back. So what is the difference of the car? Because I'm pretty sure they sold the car. It's been 10 years. So I'm pretty sure they sold the car. So what's the difference of them selling the car? Because I never got anything. I never got nothing. I was on dialysis for 7 years. Got a transplant, back with health issues again. I was not able to drive. That's why I asked them to come get the car. They took 4 to 5 months to come get the car. So I don't really know at this point what to do about this situation.
All right.
This
Well,
is not on my credit anymore. It's not on my credit anymore. It's been deleted off my credit. So I don't know. I never been through a garnishment before. Never.
well, I can't give you legal advice because I'm a judge and judges are not allowed to do so. So, as far as what to do about the situation, you'd have to seek legal counsel for that. At this point, Mr. Chisholm, what is your response, sir?
So Your Honor, is the court, it sounds like is well aware and kind of, I think made a reference to, MCR 3.101K1, forbids attacking the underlying judgment through an objection to garnishment. And it sounds like that's exactly what's going on here. I'll note that this case was served personally back at the time that it was filed. And there was a default judgment entered in the amount of just about, it was $9,833.20. Default judgment entered back in early 2015. There have been a number of payments actually on the account over the years, and there that total number of payments. I apologize, Judge. I'm trying to flip around the screens trying to find the exact spot. So $2,012 has been applied to the account previously, I believe through tax and other garnishments. They're very odd totals. 43.58 and 101, 103.88, 53.89, just very, they look like small wage garnishment totals. And then it does look like last year, 4/17 of 23, a garnishment was paid for $699. That our code indicates that is from the state of Michigan, third-party withholding unit. So this isn't new. The Reliable has been collecting on this, and for the record, Judge, there was interest assessed on the account, contractual interest up until July 1st of 2017. That was turned off on this account. No interest is accrued since July 1st of 2017, but there was some interest for a couple of years that did accrue. So as of the court, the balance, last payment on it, like I said, was in April of 23. No payments have been received since then. There is a valid judgment. There's still a balance owed and outstanding, and any grounds to properly object to this garnishment.
Thank you.
Okay, I have a question. He said I was served in 2015.
January 10th, 2015 at 11:32 a.m. at,
Served, served
I'm
to
still
who? Me?
talking, ma'am, at 2308 Holmes Road in Ypsilanti Township by a Christopher Drew, who is the
I
person
don't
who
live there.
filed, who was the person who filed the proof of service. Ma'am, the problem is that once a default has been entered, you have up to a year in order to try to contest that. And that is still questionable as to whether or not you would be successful. It has been at this point 9 years, so that is not something that you can attack anymore.
So he's saying he served me. He never served me. I don't live there.
Okay, well, like I just said, you are no longer able to attack that issue because it's been more than a year since they filed a proof of service indicating that you were served with that back in 2015. So the only issue before the court is whether or not you have a adequate objection to the actual garnishment, because you cannot attack the underlying case anymore based on what the law says. Having said,
Well, I do have an objection. I don't work. I can't work. I'm disabled for life. I get disability, so I don't know where else this is going to go, but I can't pay it. So I don't know what to tell them. I gave the car back. I mean, I'm stuck with health issues. There's no way I can pay it. So, and for them to keep coming after me after a car I gave back to them, and they're serving people that where I don't even stay, so it's just don't make sense to me. And I got this in the mail around October, November. And that's how I'm like, what? So I don't really know what to do about this.
okay, one moment. So this agreement was initially entered into on June 22nd of 2011 by Ms. Hall and Q0XxA7 at the time, and it required that she make payments on the vehicle that she had bought at that time. The lawsuit was filed. There is a proof of service in this case that goes back to 2015. Therefore, any and all ability to actually challenge that has surpassed by a number of years, especially in light of the fact that there have been previous well, let me say that she failed to appear and then a default was entered. The default was entered on February 12th of 2015 when she failed to answer or defend the case in any way, shape, or form. Then there were garnishments that have been issued in this case over the course of the years. The court has, through its predecessor, signed 1, 2, 3, 4, 5, 6, 7 garnishments. No more than that. 8, 9, 10, 11, 'This looks like this court has signed at least 11 garnishments in this particular file, 12 garnishments in this file prior, 11 prior to this one. This was the 12th garnishment that was filed that is now being objected to. And Ms. Hall has been on notice, or should have been on notice, based on the fact that they've been taking monies from her treasury tax filings with the state of Michigan. They've sent it over to her. It looks like this was an employer options plus back in 2017. They sent it to no one's the unclaimed property. She wouldn't know about that one. That's another Department of Treasury. Dollar General Corporation back in 2021. NLRTH Michigan LLC in Canton back in 2022, which seems to be another employer. So there's been ample opportunity for her to know about this lawsuit way before now. And this is not an appropriate objection to the garnishment at this time. The motion or the objection to the garnishment is denied. I will say this, that if she only has disability, then obviously there won't be an ability to attach to her disability based on the law. But as far as her taxes are concerned, the garnishment objection is denied. So.
Thank you, Your Honor, and I will make sure that,
Thank
you know, again, I'm sure the court's aware, but for Ms. Hall's reference too, I'll make sure that no bank garnishments ever go out on this account, because those, you know, certainly sounds like the funds that might be there. Anything that they would ever recover there would be exempt. So I'll make sure, if it hasn't already been done, that is noted.
Yes.
Yeah.
Yes, you may, ma'am.
Okay. May I go back to what you was talking about, if you don't mind, please? About the garnishments and all the missing and all that.
What about it, ma'am?
I was on dialysis for 7 years. I would never know. Going four times a week, 4.5 hours a day to stay alive. So I would never know about a doggone garnishment. So that I would never know. I never got served a garnishment. I only seen this and Secretary of State. Well, not Secretary of State. What is it? The state of Michigan that sent me a paper this year, and I would never know. I never knew. And a few jobs that I had, I didn't even last long. So, because I was always sick, so I can't work. So they wouldn't tell me anyway. It's against them to tell me if I was getting garnished or anything.
That's not true. They're
me.
supposed to tell you, and you would have been served with all of these documents, ma'am. There's proof of services in the file.
I was not served with anything. I don't need to lie on court under the oath. I wasn't served anything. But this one I just got October to 516 Auburn Drive. I don't know how the mail was running there, but I got it around October, November. And I was like, what is this? Why is these people trying to garnish me? And then the state of Michigan sent me a paper. And that's why I came up to the court this year and was like, no.
You muted yourself, ma'am.
That I would never know nothing about this.
All right.
Trust me. Yeah, I would never know, or I would have responded then. I don't keep myself limbo when it comes to stuff like this. But as far as this is my first time ever seeing this.
All right.
So that's why I came up with it.
My ruling still stands. Thank you.
All right, thank you.
Thank you, Adam. Have a good day.
You're welcome.
Luck,
Have a good
ma'am.
day. All right, so who do we have for portfolio? Right, we don't know who's here for, oh, okay. Are you here? Which matter are you here on, Counselor?
Hi, Judge. Portfolio recovery versus Rick Eden.
Perfect. You guys did great. All right. All right, and then we need Rick Adams. We got him. All right, the court will call the case of Portfolio Recovery Associates LLC versus Rick Adams, case number 13C 1252.
Michael Kirschneider for the plaintiff, Your Honor, P75722. How are you?
Well, how about yourself?
Not too bad.
All right, we are here today. Mr. Adams, please state your name. Mr. Ricky Adams, please unmute your device, sir, and state your name. Mr. Ricky Adams, this is the last time I'm gonna call your name, sir. If not, then I'm gonna have to pass this case. You have to unmute your device, sir.
I keep hitting unmute.
Okay, please state your name.
Ricky Edens.
All right, thank you. Mr. Adams, this is your objections to the garnishment in this case. You're indicating to the court that you're objecting to this garnishment because you say the judgment has already been paid?
I paid for another company. Okay. Can you tell, no one can tell me my original creditor. Can I get that from the attorney?
1 second. Midland Credit Management.
Correct, Judge.
Okay. That's another collection agency.
Oh, they say you entered in a contract with, oh no, that is, you're right, that's the assigner.
It's sold like 3 or 4 times. If it's credit, if it's Capital One.
Who was the original creditor? Do you know, Counselor?
Judge, the only, I don't, because of the age of the file, I don't have in my system the original creditor. Just that I have Midland Credit Management to portfolio recovery.
Do you have a account number or anything like that?
I do. Yeah, I have an account number ending 9686.
Do you have your account number, Mr. Adams?
No, I don't. But I settled with Charlotte House. Their original figure was 1603.64, and I settled for 375 just in February. And they told me that was from Capital One. Only had one Capital One back then, but then I'm being told by this company it's Capital One.
This is, you say you settled in February. This is a 2013 lawsuit.
I just settled it in last month. Isn't
But
that
they-
original card from 2005? See, that's what the confusion is. This thing's been sold probably 4 or 5 times.
I don't think has it been sold since this lawsuit, Mr.
No, Judge, Portfolio Recovery has owned this account since, I mean, at least since we filed the lawsuit in 2013, judgment entered in 2013. The judgment was renewed in 2020. I will indicate the renewal was sent to the same address defendants listed on his objection. I'll also indicate, obviously the court's aware that and obviously I know the court let him make his case, but he can't really attack the underlying judgment with an objection to garnishment.
But I don't think he's attacking the underlying judgment. I don't think he's attacking that. It sounds like he's saying that he believes that he paid this account since it's been a judgment.
Well, he certainly didn't pay it to the current creditor.
No, I paid the creditor I had on file from years ago, and they paid me. This is, I mean, if you can tell me the original creditor, and then I can understand better. But only one I've ever been in court with is Capital One, and I'm being told by someone in your office it's Capital One.
Why are you saying it's his office that you're being told that?
I spoke to, what's her name? I guess she was a case manager, a file man. She had my account, and we went back and forth for a very long time. And I was out of work for 10 years. And I just started working again, and no one notified me. They notified my company of this writ.
Sir, I want to stay on task with the question that I asked, which is, can you please explain to me why you're saying you talked to someone in his office?
I did. I talked to this Weber, right? Weber and Olise?
Yes, Weber and Olise is my office.
Okay, do you have a Marcia, or I just, my notes are all messed up. I apologize.
Marla,
thank you. And she couldn't tell me. She thought it was Capital One, but she couldn't tell me where the original debt came from, which I find, almost impossible to do if your portfolio bought it from Midland, and no one knows where the original debt came.
So you're saying you settled an account, you don't know what that account was when?
No, I settled Charlotte House. Is Capital One. I got the paperwork it's in my phone for the shoot. I'm sorry. Can I ask him how much was the original debt?
The original debt was $1,412.03.
correct.
See, that's close to Charlotte House via.
Close is not the same as being the same, sir.
Okay. Fair. But I know they added their own different fees to these things.
Sir,
I mean, this credit card had a $300. I'm sorry.
Mr. Edens, if you're claiming that you paid an account and you paid this judgment off since it's been a judgment, you are the person who's required to prove that you paid this off, because they've already gotten a default judgment in this case. So you can't attack the underlying piece of this. That's done. The question before the court right now is whether or not you paid this judgment, and that's your responsibility to be able to show that.
Can I forward my paperwork to the courts and get a postponement or something?
Mr. Kirshenheiter?
Oh, I have no issue with that, Judge. And I'll look into it, see if I can get any more information on my end. Obviously, I didn't anticipate with him indicating he had paid it. He meant he paid someone else on something. So I wasn't. Unfortunately, I don't, because of the age of the file, I don't know what I'm going to be able to get. But I will definitely reach out to my client to see if there's anything they have that I don't have.
All right, and if you can find out any additional information about who the original creditor was, that
Of
might help
course.
to streamline this process. All right, I'll bring you all back here on April 4th. Can you look up that date before for me and see what is available? All right, I'm gonna set it for 2:30 on April 4th. Does that work with everyone's calendar?
That's fine for me, Judge.
Yes, it does.
Thank you. We'll see you then.
Thanks, Judge. Have a great day.
You too.
Thanks, Judge Washington.
You're welcome. Thank you. Yeah. This is typewriter. Yes. Typewriter Credit Services versus Tika Gregory, case number 17C2631.
Good afternoon, Your Honor. Jay Lazar on behalf of the plaintiff, P69480.
Good afternoon. Tika Gregory, please state your name.
Yes, Tika Gregory.
Thank you. Ms. Gregory, we're here on your motion at this particular point in time to set up a installment payment plan. Is that correct?
Yes,
All right. And you indicate
yes,
That
Your
you-
Honor.
working at
Oh.
St. Joseph Village Senior Community,
Yes,
and you just started full time,
yes,
and you're asking for $100 per month.
yes. if possible, 150.
All right. Response from you for Tidewater, please.
Yes, Your Honor. I don't know how much from the previous hearings Your Honor is privy to. So stop me if I'm saying too much, or if you prefer me to say more or less. This originated many times with Magistrate Nelson. I apologize, I don't remember the new magistrate's name we were in front of last time.
Rayleigh.
Yes. So if you look in the file, Your Honor, this goes back quite a ways. This is not just the first garnishment with the first motion for installments. The reason, and if you look, my client actually has foregone these hearings many times, despite filing garnishments. It's been kind of a vicious cycle of the garnishment being filed and then an installment plan and the garnishment, the installment plan with no actual payments coming in. My client's reason for objecting here is not the amount. It's that it's been up and down. No matter what the amount has been, the willing payments do not come in. The only funds that ever come in on this through the years is via a garnishment when it's been in place. But the problem we're having here, Your Honor, is the last payment on all these installments was 2022, March. It's over, or about just about 2 years ago. The payment before that was January of 2021. Before that, July of 2020, then 2019. So there's been almost no payments made on this. This is quite an old file. The original agreement came with a consent judgment of installments that didn't get honored. So my client is not saying they will not honor, and this is what we said last time, and we've said to Ms. Gregory before. My client's not saying that after some time they won't do an installment plan, but as of right now, they are asking that the installment plan be denied and have at least 90 days of the garnishment to run to actually get some payments coming in on this. Because this, again, this has been quite some time going where we just haven't had anything. We've only had a few $100s since 2019. It's in 5 years, there's been, less than $1,000 paid. Again, I don't have the exact number. I'm sure Your Honor can see in the file, there's been installment plan after installment plan. And it's right after garnishment's been filed, and nothing comes in. So the long story short of it, Your Honor, if you look at the history, my client is just saying, let the garnishment run for 90 days and then we can entertain the installment plan based off the history of the file. But again, it's not the matter of the amount. They're just objecting to the installment plan in full right now due to the history.
So my notes indicate a couple things that are kind of concerning for me. One is that it looks like, well, I don't know how Attorney Charles Grove's information got on here. I'm looking back to try to find the actual appearance. I don't see where Attorney Charlie Grove ever filed an appearance. How did his name get on this?
Well, he had negotiated the original consent judgment. I do know that. But he's been off this file for
From
quite
years
some
ago.
time.
So he's been off the file. So I'm not understanding why the magistrate wrote this.
Yeah, Your Honor, again, I'm not certain why we came back either. My understanding of this is that back in 2018, 2019, maybe even before that, it might have been 2017, he negotiated the original installment plan via the consent judgment, $200 a month in the consent judgment. That was in October of 2017.
That's okay. I understand now. All right.
Yeah.
So I can tell you, Miss Gregory, you were before me, actually, back on October the 7th of 2021. At that time, you were the only person that appeared, and you told me that you were going to make your first payment on tomorrow, which would have been October the 8th of 2021. And you asked me to do an installment plan for you at that time. And so an installment plan was done. Now I'm hearing that you did not comply with that installment agreement. Why would I do another one?
Because, ma'am, right now this has just put me in a homeless situation. Ever since December of 2001, I have been homeless. I just recently, in September, me and my son got an apartment through the Delana Center, which helped me pay with that. I just recently got full-time at this new job and got willing to pay, and I'm not, saying I don't owe, but I don't want to be homeless and trying to pay something, if that makes any sense. I have paperwork right now that I have a judgment saying non-payment of rent for this month. I wish my Zoom work.
Well, you're not, well, that's what I don't understand. You tell me you have a full-time job, but now you're not paying your rent either?
So my rent was coming out automatically now, and with the garnishment coming out automatically, it set it back, and yeah, so now I'm $849 behind because of the garnishment now.
How much, Counselor, how much does your client have that they're holding at this time?
I don't have an exact amount here. The garnishment just got going. I do believe it's about $350 to $400 every 2 weeks. So that does leave, if that's 25%, that would leave $1,200 every 2 weeks for rent and whatever else she has.
Your Honor, may I speak? It's $1,000, and my rent is $11.
I saw that your rent is 11. I get that, but the point of the issue right now is that you have not made any payments, and I'm trying to find out.
I have made payments, Your Honor, after me and you spoke.
How much has she paid since October the 7th of 2021, Counselor?
Bear with me. I can get you that exact number.
Okay.
My computer is scrolling up as fast as it can to get to that date. You said October what? I'm sorry.
She saw me on October 7th of 2021.
Okay, October 7th, 2021. Okay.
I also have money order, too.
I don't know what that means.
I also have a money order I paid after me and you spoke. Actually, 2, so it should be like 400. 2 payments, maybe 3.
I'm showing since October of 2021. I'm seeing 1 payment. If you bear with me, I'll make sure there wasn't 2.
Of course.
But from my original notes, I do believe 1 since in the last few years to be accurate. Hold on 1 second. I'm stuck on October 4th. Hold on 1 second. October 7th. Okay, here we go. Your Honor, I'm only seeing 1 payment in the 2.5 years or so since that date.
Thank you. All right. This is what I'm going to do, and neither one of you are going to be happy with it. I'm going to order that the funds that are currently being held will be applied to the judgment, but I'm going to allow an installment payment after that time period. And I'm trying to figure out how to effectuate that. So if you have $1,000 or $800, you can apply that, but then she can go into an installment payment of, so you said you can do 150, ma'am?
Yes.
Your Honor, there's no money. The money's currently the money we just discussed, that 350 and the 400, that just came. There should be nothing further other than perhaps the next paycheck being withheld.
Well, she says it's 1,000. So maybe they've already taken that other paycheck? And you
Well,
just,
that would add up then, because if we're at 750, I just want to make sure your honor understands there's not $1,000 more waiting to be turned over. It sounds like there's about 350 more waiting to be turned over.
okay. All right.
I believe was the request 150 every 2 weeks.
No, what is the request, ma'am, so that we're all clear?
It's monthly, if possible.
Oh, I thought the last hearing we discussed every 2 weeks.
It says, I asked the court for an order allowing installment payments of the judgment in an amount of $100 every 2 weeks. So it's 200 a month, $100 every 2 weeks is what you said.
Okay, ma'am.
So when is your next paycheck?
My next paycheck, ma'am, will be the 22nd of March.
All right, beginning
And
of
right
March.
now, yeah, the 22nd of March. And right now they have already taken 1,000 and sorry, bear with me. I don't know how to read this. It's 1,000 and something. I don't know, ma'am. I can't read it.
All right, well, they're gonna keep that. Are we talking about the garnishment that was issued on September the 7th of 2023? Or no, I'm sorry, the issue. On March 9th of 12/21 of 23, is that the one that is effectuating this, Counselor?
Your Honor, I'm
I
not
think it's
certain. I'm sorry.
I think it's
like March 8th, I think.
December 21st. Is that to Trinity Continuing Care?
Yes, ma'am.
All right, December the 21st. Any funds that are deposited with the court or held by the garnishee at this time are going to be turned over to the plaintiff's attorney. And in addition to that, ma'am,
Yes. Oh, I found it. It's $1,172 that they've taken since March 8th. Okay, yeah.
so you need to make a payment on March 25th or another one on April the 8th.
Okay. Of the 150, correct?
No, $100 every 2 weeks for a total of $200.
Okay. So,
And I'm gonna bring you back here on April the 11th to see if you've made those payments. If not, I'm ceasing all orders and you will no longer have a payment plan. And I won't issue one in the future.
Okay, thank you so much.
So I'll see you on April 11th.
April 11th, okay, what time?
Counselor,
Your Honor,
you?
I'm sorry, Your Honor. Could we ask that date's contingent only upon if she doesn't make payments? If she's okay, can we just not appear?
Yes, that is correct.
Thank you.
All right. April 11th, 2024 at 2:30 p.m.
Okay,
If defendant is making payments, no one needs to show.
okay. Ma'am, Your Honor, can you tell me one more time, when I have to start paying? Is it March 25th or 22nd?
It's the 20, so the 22nd is when you get paid. I don't know that you can get it in on that same day that you get paid. That's why I'm giving you to the 25th, which is the Monday afterwards.
Right, thank you so much.
You're welcome. All right.
Thank you, Your Honor.
You're welcome. Thank you, sir.
Have a good day, everybody.
Thank
You too. Bye-bye.
you too, thanks.
All right, good afternoon. The court will call the matter of Nazar versus Farm Bureau General Insurance Company, case number 24C0594.
Good afternoon, Your Honor. Patrick Rooney on behalf of Nazar Nysak.
Good afternoon.
Good afternoon, Your Honor. Maggie Mason on behalf of Defendant Farm Bureau.
Good afternoon, everyone. So welcome.
Thank you.
We think.
I don't know. I think we better deal with some preliminary matters first. So I know that the parties stipulate to come to the 14B District Court, and I understand that the rationale behind the reducing it to a district court case is because it's under $25,000 in dispute. Is that accurate?
Yes, Your Honor.
So that only brings me to the question of how you got to 14B as your proper venue.
So the circuit court made the determination that it would be 14B that would be the district court receiving this matter.
Do you know what that was based on?
I think it was based on the locality of the accident, Your Honor.
I think the circuit court may have made a mistake, which is what I thought too. Michigan Avenue Prospect is where the accident occurred, correct?
That sounds correct without
Yeah.
pulling the police report and looking. It sounds correct.
That's the city of Ypsi, not the township of Ypsi.
Um,
So does that put us in 14A?
Yes, it does.
Okay.
so what is, well, so there's a couple of things there. One is that in reviewing the remand statute, it essentially was eliminated. There's really no direct remand from circuit court to district court anymore. There's removal from district court to circuit court, but it was a stipulation between the parties. I think with respect to Michigan law, venue is appropriate anywhere where the defendant conducts business. So I understand this is a bit odd.
No, you're right. You're correct. That is true. That if it's anywhere that the defendant conducts business, and you can bring it anywhere in the state of Michigan or wherever you want, essentially. So that part is true. If you choose to want to stay here, I can't tell you the venue is not proper.
Well,
I can tell you that this is not the situs of the actual accident, though.
right. Well, so moving things is a lot of work.
Okay. So therefore,
I would prefer to stay before the court unless there's a compelling reason not to, such as You will regret the day, Mr. Rooney, that you said you wanted to stay.
That is not who I am.
It doesn't strike me as such, Your Honor.
All right. Having said that, are there any other preliminary matters that we need to address?
Just would like a little discovery, that's all.
There's been so much of that, it looks like so far. I know that there's still that outstanding issue with respect to Mr. Kyle. I don't know how to pronounce his last name. Yeah, I noticed that the warrant was recalled while this matter was sent on remand, so it was not outstanding. Has that been addressed in the interim time period?
No, Your Honor.
It is not, Your Honor, and I was waiting for our first conference here to discuss. I would like to petition the court to reissue the bench warrant. I haven't done that yet. I just got the notice 2 days ago, so.
Okay.
And
All
that's,
right.
that's essentially an extension of discovery. So I'd like the deposition of the claims adjuster, Your Honor.
I see.
I thought we were gonna have, some ability to resolve this, but I don't know if the court is familiar with the expression, a tempest in a teapot.
No. I'm not. I don't know if I want to become familiar with it.
Well,
Starting today.
A teapot is a small thing, but inside if somebody's stirring really hard, frothing things up, it's a tempest, a storm in the
Gotcha.
teapot. And that's where we're at. They're spending more money defending this case than it would cost to just resolve it.
So this is a first party,
Yes, Your Honor.
and Mr. as I, I've tried to come up to speed with this, but it sounds like the Kyle individual allegedly was the employer of Mr. Nysak,
Yes, Your Honor.
and
Cash payments and Venmo payments. So even if he comes in and testifies, yeah, I paid him, I didn't pay him. I've indicated to Miss Mason, there's case law on point that says that testimony with respect to working and receiving money is enough. You don't have to have W-2s and tax returns. And so it's a question of fact, regardless of what this gentleman testifies to.
And I understand that, Your Honor. However, what I have for proof of work right now is 2 screenshots from Cash Apps.
And testimony from the plaintiff. And again, I can't even remember what we're talking about, like 2 months or something like that of wage loss. It's again, not a whole lot.
That's what the claim is for, 2 months of wage loss.
That there's a Medicaid lien that has to be reimbursed. And there's some replacement services that we apparently don't really disagree on because Ms. Mason has indicated that there is enough proof for that. So it's a limited time period, limited claim, but they want to just say, well, not enough proof. So let's keep going. So,
excuse me, if we're talking about 2 months, you're trying to figure out from Mr. whatever his last name is, Holderdike, that what the exact number is. Is that what you're trying to figure out? I'm trying to understand why we'll be issuing bench warrants.
Yeah, so during the deposition, Mr. Nysak kind of flaked on the dates and when he worked and when he didn't work and when he took some time off, and then I got 2 screenshots and he said Mr. Polderdike was a snowboarding buddy. And there's no proof that he worked. There's no proof that he made, X per hour. He testified that he was taking, this is like a 23 or 24-year-old kid taking, vacations and summers and that kind of thing off. I just want Mr. Polderdike to say, yeah, he worked for me. This is what he did. This is what I paid him, that kind of thing. And we tried to serve him 3 times. He puts it in his hand. He drops it in front of him on the porch and says, I'm not taking it. And I have affidavits from the process servers every time. So
with all due respect, that's not the only thing that you want. So what you want is to attempt to impeach my client with this gentleman's testimony, and you want something that he doesn't have. So, which is the proof of payment. So
I appreciate you putting words in my mouth, Mr. Rooney, but
well, you put words in my client's mouth.
Everyone, hello, everybody, stop.
Okay.
This is why I could tell from this file. I knew that this is what this was going to be like. I already knew this.
It's
So,
just such a small amount of money we're really arguing over, but
yeah,
there's no reasoning here. As I indicated previously, under Michigan law, even if somebody is temporarily unemployed, they're entitled to a wage loss claim. So even if you want to say he wasn't working at all as a result of before this accident or after the accident, he's working now. He has at a minimum, a minimum wage loss claim for that time period. We're talking about minuscule amounts of money. And, I've suggested before, it doesn't make sense to be pursuing this, but I can't control what the defense or the insurance company wants to do.
so it appeared from reading the ROA that at one point in time you all were sent for case evaluation and then it got canceled. Did it ever get rescheduled? And is that accurate?
Did we have case evaluation?
I remember writing the brief. If you give me a moment, I'll look it up.
We had a facilitation in lieu of.
Well, that's what happened.
Yeah,
Yeah,
I think you're right.
and spent good money on a facilitator just to be told we don't have enough proof. They're never going to have enough proof. So
We also don't have proof of some of the medicals that we've asked for. I mean,
well, actually,
Not
that's
that
different.
tidy.
That's different. What you asked for, you have the medical. What you have asked for are the codes associated with that medical. And I said my client doesn't have them. And you could order those records. You could get the codes, CPT codes, which, I mean, we're talking about very small amounts of money here. It's like tempest in the teapot. I'm just going to keep saying that. So I'm just asking for a little bit of discovery so I can take the claims adjuster's deposition, because there are bills here which should not be in controversy. And as I've indicated before, if we proceed to trial, the attorney fees, even if there's just one bill that the defendant did not pay that they should have paid, the attorney fees on this are going to eclipse whatever other claims there are in the case. And there's a reason we have a statute with the provision for attorney fees, and that is to try to avoid situations like the one we're in right now.
Thank you. All right, so it sounds like both of you need a little bit of discovery, so we will do that. How long do you think you need, Mr. Rooney?
I just need the deposition of the claims adjuster, so I would say 60 days just to give them time to line that claims adjuster up.
And Ms. Mason, you're gonna need to,
I'm gonna say 60 at least, because they've refused to sign authorizations for the medical records. And so I have to get those signed, and then I have to send them in, and then I'm kind of at the mercy of the medical facilities. I can't add up the damages unless, I know what they're for. So I'm gonna need to get that information.
all right, discovery will be through May 16th, 2024. And we'll do another pretrial on June 20th, 2024 at 2 p.m. And at that time, I'm hopeful that if there are going to be any MSDs or anything like that, we'll know that then. I'm presuming there won't be, based on the nature of these particular claims. But we should have all the issues regarding Mr. P already addressed. And I will let you know whether I intend to issue another bench warrant in that situation or not. So you'll have to file that in the time period. Okay?
Okay.
And will the court be issuing a written order on that?
Nope. This is all you get. You're in district court now.
Just asking. All right. Thank you so much, Your Honor.
Thank you. Have a good day.
Would you like me to draft an order just to keep everybody on track,
Why don't we do that? That would
Okay.
make sense. Okay.
Great.
I would appreciate it. Thank you.
Thank you, Your Honor.
Have a good day.
You too. Bye-bye.
One second, please. We'll call the case of Janice Williams versus Delbert Claiborne, case number 23C 2580.
Mr. Mazie.
Ready, Judge. Patrick Mazie on behalf of defendant Claiborne.
Thank you.
Good morning. Good morning, Your Honor. Abraham Snyder. I'm standing in for Joshua Parmley, who has left our firm. I believe this case is going to be handled by Thomas Langen, but I'm here today for the status conference.
You'll have to, whoever's will have to remind me of all that when you come back next time, if you come back, but thank you. I appreciate that.
Of course, Your Honor.
So tell me, where are we with this? I know we have the case going in the circuit court or the probate court.
Yes, Judge. We are ready. Clients are ready to more or less put this to rest, and so they're willing to vacate in pretty short order here without any need of a bailiff to put them out or anything like that. Our requests are that they be given some amount of time to do so, and any previous escrow payments that were ordered or expected be forgiven in exchange for leaving promptly, leaving timely, probably no more than 21 days.
So it sounds like you're having a conversation with Mr. Snyder here regarding a resolution.
Fair enough to say, Judge.
That's what it sounds like to me, Your Honor.
You want to go into a breakout room and discuss this matter?
Counselor, would you like to do that as well?
Sure. I may have to also step out of my office. Well, actually, the person I'm covering for because he's not available right now. Perhaps we should set a follow-up date with the expectation that we will get this resolved beforehand. It sounds like the terms that Mr. Mazie is discussing should be either palatable or not far off from palatable to our clients.
Judge, I'm amenable to that. I would just ask if we are able to resolve it amongst the parties, being that it does seem like we're close enough, that we wouldn't need to, as much as I love to be in your courtroom, Judge, we wouldn't need to return necessarily and waste the court's time and judicial economy and so forth.
I will say this, counsel. First of all, thank you. I appreciate that kindness.
Sure.
Secondly, at any point in time, if you guys want to resolve this case, you can draft an order, submit it to this court, and never have to come back here again on this one. Okay.
But we'll be back voluntarily, Judge, but yeah, not on the case itself.
Why don't I put it over to April the 11th, and hopefully it'll be done by then?
What time, Your Honor?
Let me get you that in one moment. At 2:45 p.m.
Very good, Your Honor.
Thank you, Judge.
Thank you. Have a good day.
You as well.
You too, Mr. Mazie. I will have Mr. Langen give you a call.
Okay, good. Appreciate it, counsel.
Thank you very much. Thank you, Your Honor.
You're welcome.